People versus Salas.
Good afternoon, Your Honors, and may it please the Court. Benjamin Brindis for the appellant, Christopher Salas. I request that 3 minutes be reserved for rebuttal.
Yep.
I'll address both issues raised in the brief, beginning with the meaningful notice violation.
Could you speak up just a bit, Counsel?
Sure.
Thank
I'll
you.
address both issues raised in the brief, beginning with the meaningful notice violation. In a line of unbroken precedent, this Court has stated the same rule that controls this case. There must be specific record proof of meaningful notice for each substantive jury note.
Counsel, you raised this issue first in a 440, right?
No, we sought a 440 initially on the ineffective assistance of counsel claim, and because we were making that motion before the trial judge, we were convening, speaking with trial counsel. It was going to be served on the respondent. Essentially, everyone who may have had knowledge of how jury note 2 was handled, because we were concerned about sandbagging if we raised this for the first time in the appellate
So it was
division.
raised in the trial court then, in that proceeding, or no?
No, there was alternative relief sought on the 440 motion. The alternative relief of reconstruction was sought. But you're correct that everyone who may have had knowledge of how jury note 2 was handled was put on notice through that there was an ORAMA issue here, and we have no reason to...
It seems at some point in that record, and I may have this wrong, that your position was there was a missing transcript pages, and a portion of the transcript was missing, and that you were entitled to a reconstruction hearing.
We were noting that there was no transcript for how jury note 2 was handled.
And before today, you never asked for a reconstruction hearing.
No, we sought reconstruction as alternative relief in the trial court. We raised this ORAMA issue in the appellate division. And again, as alternative relief, we sought reconstruction. But this
What was the primary relief, if that's the alternative relief?
vacater under ORAMA, because
Okay.
it's not contested
For the
here.
ORAMA violation?
For the ORAMA violation, and specifically a meaningful notice ORAMA violation. There's no dispute here that the record is devoid of any proceeding when meaningful notice could have been given on note.
So are you asking for a ruling if a transcript is missing, that there's a presumption that there was a violation
No,
that requires what the relief that you're asking?
no, to the contrary, this court has found that there's no presumptions here in either direction. The issue is that the record is dispositive of whether meaningful notice was given. And
in normal ORAMA situations, you have a transcript. So, and it focuses on the court making an error. Here, what was the error of the court?
well, the error of the court is the same as it was in Silva and its companion case, Hansen. This court addressed this issue just over a decade ago. In Hansen, what the record showed is basically on the day the verdict was given, the court comes on the record and says, we have a note, they have, the jury has reached a verdict. And the case file there, just like the case file here, contained substantive notes that were not addressed on the record by the court in Hansen.
But
Counsel,
they weren't
you just-
addressed because they were missing, and you acknowledge that they were missing, right? So this is a different situation where there wasn't something that happens off record that isn't on the record. We know that there were on the record discussions. We just don't know the exact what they were because the transcripts are lost. So now you're asking us to put that burden on the courts to keep those transcripts?
No, to the contrary, Your Honor. The record shows that jury note 2 was handled differently than jury note 1 and jury note 3. Both jury note 1 and jury note 3 are marked on the face with a court exhibit. Court Exhibit 2 and Court Exhibit 4. Court Exhibit 3, which is jury note 2, is not marked on its face.
But we have no reason to understand why that happened or why that didn't happen, because there wasn't any diligence done beforehand to try to get information from either anyone who was present to reconstruct it, a la Paris.
Well, to be clear, we made this motion with alternative relief of reconstruction, which was served on everyone who may have had knowledge of it. It was made before Justice Carter, who oversaw the trial.
How long after it was quite clear that there was an issue with transcripts was that request made?
Well, I want to be very specific about this because we received an affidavit in 2016, the Williams affidavit, and what that affidavit said was that in response to repeated requests for the minutes, Terry Klein informed us that she was in the process of transcribing the minutes and would send them in as soon as possible. That's at the record at A96. We continued to follow up with the reporter's office and the first department until 2019. In 2019, we did actually receive additional transcripts. Those are the transcripts that show meaning of
So again,
one.
it's 2016, everybody's waiting, so it's perfectly fine to just wait because the reporter said they're coming?
Yes, we were instructed that the reporter was transcribing
But wouldn't
the
it
minutes.
indicate with such a long period of time, transcripts can be prepared daily copy, quite frankly, and a whole trial transcript, it can be prepared in a reasonable amount of time, even when it's a long transcript. It doesn't take years to produce. So my question to you is, because of the inordinate amount of time, shouldn't something further have been done?
I don't think that this court's precedent, even in Paris, requires that. I mean, the fact of the matter is I agree with you. It can be done in a short amount of time. But in 2019, we received the additional transcripts.
Do you agree that the greater the passage of time, and there was a lot of time from trial up until now even, that went by, and the more time that passes, even if one would ask for a reconstruction, it's challenging to have one that can be successful.
Well, I'd emphasize again that this court's ORAMA precedent and meaningful notice precedent in cases like Silva and Hansen don't require reconstruction before seeking relief under ORAMA.
Counsel,
wanna push-
I'm looking at the record of your 440 motion, and I believe you told me you didn't make this as part of your 440 motion, but in point 2 of your 440 motion is, your client is entitled to a reconstruction hearing to determine how the court handled jury note 2. And that doesn't ask for anything in the alternative. It just says transcript is missing. We're entitled to a reconstruction hearing. And that's what the 440 court ruled on.
Well, the 440 court ruled, and I want to emphasize that.
But I'm sorry, did you tell me before you didn't make the reconstruction motion as part of your 440, or did I misunderstand?
No, we did seek reconstruction as alternative relief
To what?
to a 440 motion on the ineffectiveness
Right.
assistance of counsel point.
Right.
And that motion was denied with leave to renew, was it not?
Correct.
The court found that although you made some efforts to ascertain what happened, you didn't, to put it, to paraphrase, you didn't make sufficient efforts, and it was giving you an opportunity to do that.
Correct. We granted multiple extensions to respondent here to conduct their own investigation. There's 8 months that passed between the
But my
filing.
my issue primarily is you took this position in your 440 that in the alternative you were entitled to a reconstruction hearing because there was missing transcript. But now on direct appeal, your position is you should just reverse because there's no evidence in the record.
Well, to be entitled to a reconstruction instance in the first instance, there needs to be evidence that a proceeding occurred that could be reconstructed. And to this day, there's no evidence in the
And you seem to
record.
be saying there was in your 440 papers, that there was
to this
evidence
day-
that entitled you to a reconstruction hearing, that there was missing transcript pages.
In the interest of judicial economy, we raised that issue at our first opportunity. We identified that there was a transcript missing
Right.
in the sense that it did not exist.
No, you said a key portion is missing. The record is incomplete. But now you're saying you don't get a reconstruction hearing.
Well, we don't believe that respondent was hiding the ball from us, when they're responding to it. If there was a transcript to be reconstructed, if there was a proceeding, no facts or evidence was added to the record that would suggest that proceeding was held and that transcript was.
Are you
Is that-
suggesting now that there wasn't a missing transcript? If there was a transcript, because your 440, again, is very clear. A key portion of the transcript reflecting the court's and counsel's handling of jury note 2 is missing. Thus, a reconstruction hearing is needed to determine how jury note 2 was handled.
Correct, it is missing. There is no transcript for how jury note 2 was handled.
So am I understanding you now, explaining why you're not necessarily pressing the issue on reconstruction? Because as you said before, all those who might have had information were served with the motion and no one came forward with information?
Correct,
That
after
would
they had...
resolve this issue? Because you were granted leave to renew if you could, I think that's what the judge, anyway, to go find information.
Well, we consulted with respondent following it, and we did not think that information, there would be information that would
What
come
does the
forward.
record tell us about that specifically? What were the efforts? So the application was denied with leave to renew. And what does the record show about what efforts were made subsequent to that in light of the court's determination that you had, quote, fallen short of pursuing other means available to increase the likelihood of effective reconstruction?
I would agree that the record itself is silent on that. The record
So were
does
there efforts
reflect...
made after the denial with leave to renew or not?
Yes, we reached out to the respondent.
Okay, but is there anything in the record that establishes the nature or quantum of those efforts?
Well, I think that the record establishes in respondents' papers in response to the 440 motion that they too had conducted investigation and they could not find a transcript and they didn't include any facts in their affidavit in response to the 440
So your
motion in connection
position
with
is
this.
that it would have been futile to take any further steps as the trial court suggested you might?
Our position is that reconstruction is not a prerequisite to a RAMA vacatur and relief under a RAMA.
So how do we,
Necessary.
in the
just-
absence of the record, which is now just part of the record that we have in front of us, how do we evaluate the claim of the court's mishandling of its obligations under 310?
This case presents on the same facts as Silva and Hansen did, and that's how this court should evaluate it.
Weren't there records in those cases?
The record was completely silent in both Silva and Hansen
Yes,
as
but
to...
we don't know whether the record is completely silent in this case because we don't have the record.
Well, no, there's nothing in the record that refers to a proceeding that wasn't transcribed. There's no reference in the record to a proceeding when meaningful notice was given, and the record shows that Note 2 was handled differently than Note 1 and 3.
I think the line of inquiry here is because there are pages missing, right? Pages missing from the transcript?
We don't know if there are pages missing
Well,
because...
I thought that was your argument, that there is a transcript, at least part of a transcript that's missing, and I think the line of inquiry is, well, that part that's missing might show that indeed the note was provided to counsel, or it might reveal something else about how the court handled the note.
I mean, that could be said in any meaningful notice context, right? Whenever
No, not
meaningful
necessarily
notice...
if you have the transcript and you can just read it.
Right, but like in Silva and Hansen, it could have been said in the briefing papers by respondent, unsupported by factual evidence in the record, that in Hansen, there was a transcript or there were proceedings, and it's simply missing.
Do you
right?
agree that if the pages of the transcript had been recovered and it established that jury note 2 was properly handled, that would be the end of it?
Well, yes, that would not present a meaningful
Right,
notice.
and so it seems to me the question is different than the other cases you cite, because the problem is we don't know what the pages say, and the pages could completely obviate any potential error.
Well, it's actually very similar to Morrison, for example. In Morrison, there was an affidavit submitted by, in that case, the appellant prosecution in the appellate division that made a record in the appellate division that meaningful notice obligations were met by the judge marking the exhibits and handing the jury notes to the defense counsel at trial. This court in Morrison did not take that into account and said that the record
Do you
governs.
think it's different, and I'm having some trouble here, where defense counsel in the 440 said there's missing transcript, and there are a number of back and forth with the court reporter's office about the court reporter leaving, pages not being able to be recovered. There's clearly two different court reporters here, and that record is developed in your 440. And it seems to me now, where I read these papers as saying there's missing transcript, and you were conceding that now you're casting that as no, there's missing transcript in the sense that there's no transcript existing that says this.
Well, I direct you specifically to the affirmation that accompanied the 440 motion, because that sets forward the facts, that the motion is relying upon. And I'd posit to you, if you review that motion, you will not reach the conclusion that it contains facts showing that a proceeding was held to give notice for jury note 2.
It just seems that's not entirely consistent with the position you took in your 440 motion.
Well, the briefing papers don't create the record and the factual record the same way that respondents' briefing papers here, in its speculation about what may have happened to this transcript, does not create a record that a proceeding was held. This applies in many other contexts in appellate review. Take, for example, the issue of preservation. If someone makes a general objection to something and then asks to approach the bench, and then there's a discussion held off the record off the bench for some reason, and they return and they don't place a specific objection on the record, there's an inference that there was a specific objection made, but that issue is not preserved for appellate review. It does not cure that.
Counsel, your red light is
Yep.
on. Could you just take a moment to address the second issue?
Yeah, absolutely. Counsel's multiple errors here transformed the identification evidence before the jury. The only identification evidence untainted by trial counsel's errors were two in-court identifications made 4 years after the incident for the first time by witnesses who were strangers to Mr. Salas on the night of August 22nd, 2007. They were first-time identifications.
Yeah, I'd like to talk about one of the identifications, because I find this very interesting. So, and bear with me, and I know the light is on, but defense counsel in his opening statement says there were never any photographs shown. The judge decides that opened the door to an identification. The judge doesn't decide, as defense counsel suggested, look, judge, just ask the question, were photographs shown? The judge says, no, I'm going to allow in an identification that took place the night of the murder. A few hours after the murder, I'm allowing somebody to come in and talk about that identification.
Only contemporaneous identification.
Right, but that wasn't the defense attorney's ineffectiveness. I don't know. I want your opinion on this. That caused that. I think the judge came up with a disproportionate remedy of actually bringing in an identification that now the defense attorney has to deal with for the rest of the trial.
Well, the prosecution specifically sought this relief immediately before Mr.
Correct.
Urena testified, and they sought relief similar to this immediately after the decision, the misstatement was made. So it was directly the result of trial counsel's error that brought in the only contemporaneous identification they heard.
I know, I guess that's what I'm struggling with, because the error was, I take it, the statement at opening that there were no photographs shown here. And from that statement, the judge makes a ruling that an identification is going to come in. So now a defense attorney has to deal with the fact that this identification is coming in. So are you ascribing the identification testimony to that error where he said there were no photographs shown?
Correct, because that contemporaneous identification was categorically inadmissible.
But the defense attorney never said anything about an identification.
In the context of what he's saying, he says no, there were no lineups shown to witnesses, there were no photographs shown to witnesses. It was impeaching the quality of the investigation. And it did open the door, as the people took the position at trial, to that testimony. And I want to emphasize that there were three theories of misidentification during the opening statement. It was that no witnesses had prior encounters with Mr. Salas, all of the witnesses would be close friends with the deceased.
Well, do we know at what point the people told him that that witness was actually coming in? Is it feasible that when he opened, he understood that that person wasn't coming in, that had the prior familiarity with him, and that he would only be dealing with those two witnesses?
Well, he had been led to believe that by the prosecution's statement, and they described it as a definitive representation that they're not going to call Urena. And Urena,
Right, so then how is it ineffective for him to say, basically, you're not going to hear at this trial that anyone had a prior familiarity with him, or whatever it is that he said, if he was under the impression that that witness wasn't coming in?
well, because he did not move for a mistrial after the prosecution changed course on that definitive representation. The prosecution can't engage in a bait and switch where they make a definitive representation prior to trial when the defense counsel selects the defense that they're going to make and makes these representations that there were no photographs shown, all of the witnesses were close friends of the deceased, and none of these had prior encounters with Mr. Salas. The very first identification witness that the prosecution called was Mr. Urena, and Mr. Urena on direct, the information was elicited from him that he had never before even seen.
Yeah, I guess, again, that goes back to the remedy that the judge came up with. So now, of course, a defense attorney has to elicit this identification because it's coming in. So he's going to try to temper it and bring it in on his terms.
It wasn't brought in by the defense attorney. It was elicited by the prosecution, who also elicited that he had a prior encounter with Mr. Salas.
I thought in your papers you said that part of the error was the fact that he elicited that the identification occurred via a photograph and that he did that through his cross-examination.
That was after the identification had already come in. Mr. Urena testified on direct that he had identified Mr. Salas to Detective Geary without any mention of photographs. That happened on direct. It was only
Right,
after
pursuant
that
to the judge's orders.
Pursuant to the judge's orders that were the result of the error during opening statement, where he opened the door to this photograph identification that was inadmissible. I recognize my time is up. So.
You do have your rebuttal time still.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. Excuse me. Gamaliel Marrero for the respondent. On point one, Your Honors, I do think it's incumbent upon me to clarify the record a bit to explain exactly what happened here. So initially, the defendant received an affidavit in 2016, a certified record on appeal, including an affidavit from the court reporters. Now, yes, in that affidavit, the court reporter said the stenographer, Terry Klein, told them she's working on it. But it also says, this is at page A96 of the appendix, our most recent request for Ms. Klein to send in the portion she already has transcribed and to estimate when we can expect to get the entire minutes has gone unanswered. Without the cooperation of Ms. Klein, we are unable to provide the required transcript. So it wasn't simply, well, we were told she's getting back to us. The stenographer is being uncooperative. So even in 2016, there was reason then to pursue reconstruction. But fine, they wait until, I guess there's a phone call or two, we don't really know, it's not in the record, but they get a portion of transcripts in 2019, 3 years later. I believe the afternoon of May 25th, 2011, and the afternoon of May 26th, 2011. It's still incomplete.
Is it to pursue an actual reconstruction at that point, or to at least alert those who may have been involved before that if they have information, it should in the very least be preserved?
I'm sorry, Your Honor, well, that wasn't done here.
In this particular instance, when 2016, there's equivocation as to does it exist, when will you get the transcript, and there is you argue that maybe there is a concern at that point that a reconstruction should have been requested. But even if, at that point, it's not risen to the level of, you need a reconstruction, might it alert one there's a problem with the transcript, and if there is information that may be needed going forward for reconstruction, one should at least take efforts to preserve that.
Yes, Your Honor. And that's what this court said in Paris, that if you learn that minutes are missing, at a minimum, reach out to court personnel, the judge, the prosecutor. And I just want to add, according to Paris, simply filing a motion for reconstruction and putting, the DA's office and perhaps the judge on notice, that is not sufficient. That is not a threshold showing that reconstruction can actually be accomplished. Before you get the reconstruction hearing, you've got to show that you've taken these initial investigative steps.
Counsel, my sense of this record is, and there's another letter in 2019 talking about missing notes and unable to get them, that the entire focus of this 440 was on trying to find missing pages and having a reconstruction hearing.
Well, frankly, Your Honor, that wasn't really the main focus at all.
No, but on that part of the hearing, there was no allegation this never happened. It was we can't find the transcript where it may have happened.
Right, and as you read in the 440 papers, the defendant said at that time, without the portion of the transcripts, we cannot determine what happened with jury note number 2. And I just want to read something from the 440.
So is that creating a presumption? There's a missing transcript, therefore there must be an ORAMA violation?
No, not at all, Your Honor, not at all, Your Honor.
But doesn't it, or would you at least characterize it as your adversary asking for that, a presumption of irregularity, basically?
Well-
We don't have the transcript, therefore, because it sometimes sounds like that's what they might be asking for. Since we don't have the record, you have to assume that they didn't deal with Exhibit 2, the court didn't deal with Exhibit 2 correctly.
That's exactly what
And on its face, the note is treated differently.
I'm sorry?
On its face, the note is treated differently.
Well, it's treated
It's
differently.
sandwiched between two other notes that are treated very differently.
We don't know who treated it differently. That's where Myers comes in, this court's decision in Myers, because we don't know who treated it differently. Perhaps the jury never submitted it, and that's why the bottom section was not filled out for jury
Okay, so
note number 2.
let's take the hypothetical. There's absolutely no way to know. We just will never know. Just assume no one is around to who recalls or they are deceased. No, there's no way to know. Who bears the consequences of that?
Under Paris, the defendant. The defendant. Here, you have missing transcripts. It's not just the ambiguities in the jury note. You have missing transcripts. And there actually was a factual determination that those transcripts were missing. That's at page 7 of the 440 court's decision, where it says, to date, the transcript record of the colloquy between the parties and the court as it pertains to jury note 2 is irretrievably lost. That was a factual finding by the 440 court based on.
But the court gave them leave to go and try and get information to support the request for a reconstruction hearing. So the
Right.
court thought maybe you could find information.
Well, that goes to the Paris analysis. I just wanted to point out that just to clarify, there was a factual determination based on the sworn affidavits of the stenographers and the incomplete transcript that was available, that the note, there was a transcript and it was irretrievably lost. And in fact, the defendant did rely upon that factual determination in his brief to the appellate division. He cited to that in reliance on his argument there.
Put the jury note and ORAMA aside for a second. Suppose the entirety of a defendant's trial transcript is missing and the defendant wants to appeal. Where does the loss of the transcript fall?
Well, I would say it would still, you apply the Paris analysis. I mean, Paris analysis
Which
applies
is
to
basically
missing
your trial transcript is lost and so is your right to appeal.
No, Your Honor, because you can still pursue reconstruction.
Well, suppose it can't be reconstructed. Same facts we have here. There's no way to get the transcript and nobody remembers it.
Well, in Paris, the inability to reconstruct did not automatically guarantee reversal.
Okay, so your answer here to my hypothetical is if a defendant's entire transcript is lost and there's no way to reconstruct it, no record of what happened at the trial, defendant has a bunch of things he'd like to raise as errors, he is just out of luck.
Well, it depends on the reasons why reconstruction can't be, why it can't be.
Everybody's dead.
Well, that could be a Rivera situation where through no fault of the defendant, I think the defense attorney was disbarred. I think the judge maybe suffered from died.
But why is it the defendant's burden to bear if the entirety of his trial is lost?
Well,
Why is that fair?
well, Your Honor, we don't really have to even reach that because this is not this sort of extreme example.
But that is the Chief Judge's
That is the
question.
Chief
And it is
Judge's-
important because you said if it's lost, you're shifting the responsibility or that he's the one that suffers the consequences of that loss
Well, I believe-
alone.
I believe in Rivera, there was a reversal. And there are other appellate division cases where there is a reversal due to lack of transcripts. What I'm saying is reversal simply based on.
So you agree that there is a responsibility for the record to be preserved that is not necessarily the defendant's responsibility?
Well, sure, stenographers have a responsibility to, that's in the judiciary law, they're required to preserve and maintain their records. What I am saying, though, is in terms of reversal where transcripts are missing, it really depends on the circumstances. And that's
But
what this-
isn't the question really this? ORAMA requires the court to make a record of how a jury communication is handled, right?
Right.
And that's so that meaningful appellate review is available, right? And isn't the question just how far does that extend? You say parish is what governs the inquiry, but the...
Myers.
Pardon?
And Myers, excuse me, sorry.
Okay. But the alternative, I think, would be to say the missing transcript pages mean that there is not a record, and that's a classic ORAMA error. Why isn't that the better way to think about it?
Well, because Parker's language of creating a record refers to the court giving notice on the record, not.
But it's in aid of meaningful appellate review, right? I think ORAMA says that explicitly. And so the missing transcript pages are something that deprive the defendant, this is an iteration perhaps of the Chief's hypothetical, of meaningful appellate review. And the question seems to me is, where does that burden fall? Is it the court's responsibility to ensure that that record is available, even if what that means is that the transcript pages are available? So why isn't that the way to think about it?
Well, that would be an unworkable rule if, like,
Why?
because the courts do not have absolute control. A trial court judge does not have absolute control.
Well, neither does the defendant.
No, Your Honor. No, Your Honor.
And neither does the prosecutor, presumably.
No,
So
none of us-
so the question is just who bears the cost of the lost pages, right? And I don't mean the financial cost, obviously, I mean the consequence. So why should the defendant bear the consequence of the lost pages?
Because, as in Paris, he did not exercise reasonable diligence in ensuring that the proceedings can be
That seems to me to be a different question, right? That seems to me to be if we're in the world, correct me if I'm wrong, but that strikes me as if we're in the world of parish, I could never remember. Paris, thank you. If we are in that rubric, then was sufficient diligence exercised? But it seems to me there's an additional, maybe antecedent question, which is, does Paris govern this inquiry or not?
It does govern.
Yeah, but why does it, as opposed to saying there's no record because there's no transcript, and therefore there's an ORAMA error, period?
Well, the court hasn't held that before. There's never been an...
Isn't that the question before us, though, is what about the clerical error? So why decide to put this in the Paris box?
Because applying Paris would not require creating a new rule that creates this presumption of error just because transcripts go...
Does it change your answer at all that there seem to be some indications not having to do with the transcript of the proceedings, that things were handled in a somewhat unusual manner, the exhibits weren't marked the way you would hope to see them in the record?
Well, yes, Your Honor, but that's why I mentioned Myers before. This court, in its unanimous decision in...
Okay, so how does Myers address that issue?
Well, where there's significant ambiguity as to whether a jury note was even submitted to the court, if there's a remedy for the defendant available, it's a reconstruction hearing to determine in the first instance whether that note was submitted, triggering the court's obligations.
Well,
So
would you agree
avenues here.
that, would you agree that on the record here, we could conclude that a reconstruction hearing would be futile, or no?
No, Your Honor, the defendant certainly hasn't made that showing. Again, that's the defendant's responsibility. He hasn't made that showing. He hasn't shown that the court reporter is unavailable. We believe she's passed away based on an online obituary that we find, but we don't know for certain.
Are you now opposing a reconstruction hearing?
Well, Your Honor, what we're simply saying,
I'm just asking, do you oppose it or not?
at this point, on this record, we would oppose, Your Honor.
I thought previously you had agreed that it was an appropriate course. Am I wrong about that?
Well, at the 440 level,
Yeah.
when we couldn't find the transcripts ourselves, we, in our discretion, agreed. We chose
So
not to.
why a different position now?
Well, we're in a different procedural posture. Now we're defending the decisions of the lower courts, and we're in the position.
It was an appropriate course of action before, what
Well-
has changed that would make it not an appropriate course of action now?
Well, for starters, the defendant has basically abandoned reconstruction himself. In his own brief, he says reconstruction is an inappropriate remedy, so he's not asking for it. So he
I
himself
thought
has
that that
foreclosed
was because, and
Well-
obviously they can respond, but because they were seeking vacature under ORAMA,
Well, right, because they want
okay,
a new rule.
but if there was a request for a reconstruction hearing as an alternate remedy, what has changed that in your view would make it no longer appropriate if you thought it was appropriate before?
Well, here now we already have a decision from the 440 court with factual findings. He was already told what he should do based on this court's guidelines in Paris. And so, and it is our position that the 440 court properly exercised its discretion and correctly applied the law in simply telling the defendant, take these extra steps and renew your motion. And as in Paris, the defendant here is open to the suspicion that he doesn't expect reconstruction to reveal any appealable issue, but would rather take advantage of the missing transcripts to claim reversible error. It's exactly what happened in Paris, and it's what's happening here.
Can I ask you about the ineffective assistance? Because I have a question on the record. I don't know when, and I don't know if you can tell me, the prosecutor said that Urena would not testify. Was that before or after the hearing was waived by defense counsel?
She told the judge on the record that the hearing, that Urena would not testify. That was before. So in April, I think in April of 2011, the attorneys spoke to the judge and they both said, no, there are no hearings. And then
So at that point, did the defense attorney know from the prosecutor that that witness wasn't coming in?
the defendant never doesn't say in his papers.
What did the people say?
We believe that there was likely some discussion between the attorneys because they both seem to have an understanding, not a misunderstanding as to what hearings the court had ordered, but an understanding that hearings would not be needed here.
What is the evidence in the record for that, one way or the other?
Well, the defendant hasn't provided any evidence one way or the other. He certainly hasn't shown there was an absence of a legitimate reason for waiving the hearing. All he has from defense counsel is defense counsel saying, I don't remember, I can't think of any reason, but I didn't look at my file.
Is there a point when, on the record, the people notify the court or the defendant that Urena will not testify?
Yes, it was around jury selection. The trial ADA told the court that they were not calling Urena.
So could you infer from that that up to that point in time, the expectation was that he would testify? I mean, why would you notify the court about something you'd already notified the court about?
Well, I'm not sure if the trial ADA had notified the court. The question is whether defense counsel and the prosecutor had that understanding.
And the record is silent on that.
And we're not sure. The defendant had the opportunity to provide more information on that. He chose not to. Defense counsel chose not to review his file before providing an affidavit on the 440.
Well, do you think a 440 hearing would shed some light on that?
Sure, a 440 hearing could shed light on whether there is, what the reasons were, but there's more to consider. on the defendant's 440 motion. Here, the 440 court looked at the record as a whole and found that counsel, while maybe imperfect representation in certain respects, overall provided meaningful representation. And so even if you had a 440 hearing to determine why the suppression hearing was waived at the beginning, and, or why he didn't seek to renew that request for a suppression hearing once Urena was, once he knew Urena would testify, it wouldn't change the other analysis, the reasonable probability of prejudice analysis under the federal standard, which is still an important part of the state standard. In other words, even if Urena's testimony had been removed, and pretty much all the alleged errors revolved around Gregorio Urena. So let's say we take him out entirely. You still had overwhelming evidence of guilt. You still had two strong
But we don't do
ideas.
harmless error analysis and ineffective assistance.
Well, prejudice, it's still an important part of the meaningful representation analysis as a whole. And the court did determine
But even
that.
under the federal standard, it's true under ours, of course, if there is even a single error, right, that rises to the level of ineffective assistance of counsel, it doesn't matter that perhaps the rest of the representation was pristine.
Right, but this record does not establish that kind of error. It does not establish that kind of error because Urena's testimony was not crucial to the people's case. Urena didn't even see he didn't testify that he saw the defendant with a knife. All he could say was, I knew the guy from the neighborhood, and I saw him making an upward punching motion. It was the two witnesses who he had tended to call from the beginning, Gallardo and Veloz, who testified in detail about the stabbing, about seeing the knife, and the number of times that the victim was stabbed. Urena's testimony merely corroborated the testimony of the weightier witnesses.
What about with respect to identification? Are you saying Urena's identification testimony was inconsequential?
I wouldn't say inconsequential. What I would say when I was responding to Your Honor's point, I was simply saying that as far as a single error, Urena's testimony coming in was not to the extent that it was error.
It doesn't make the attorney's performance inadequate?
Well, no, because we don't know his reasons for not objecting to the testimony or not moving for a mistrial.
What could
as
be the
counsel argues.
strategic reasons?
I'm sorry?
What could be the reasonable strategic reasons?
For not objecting to the testimony?
Correct.
Well, he could have figured that the testimony was going to come in either way. So rather than spend time raising objections and asking for a mistrial and perhaps wasting that capital with the court, he asked for a continuance to
So
get
isn't that a reason why we don't guess? You go back and you have a hearing?
It could be if there's a question as to whether an alleged error deprived the defendant of a fair trial. And I think the 440 court, in its review of the record, and the appellate division, in its review of the record, determined that even if there were errors here, they were not so consequential as to deprive the defendant of a fair trial.
Would you dispute that that's a disposition that's available to us to remit it for a hearing on the 440?
Well, I wouldn't dispute if that's.
I mean, we can do that, right?
The court can remit it for a hearing.
Yeah.
Yes, the court certainly can. We're just saying that
You're just saying we don't need one.
Exactly, we don't need one, and that the 440 courts and appellate division's decisions on the 440 were provident exercises of discretion. They certainly were not errors of law. And so we ask the court affirm.
Thank you.
I'd like to
Counsel, can I just ask you to respond to a question I asked your adversary? Why is it that the court should essentially be responsible for securing all the pages of the transcript in a way that a court is responsible for making a record in the first instance of a jury note?
I was going to address that, Judge Halligan. So again, here we don't know if there were missing transcripts, but the reason, it's important to remember that this case took place approximately 6 months after the trial in Parker did in 2011. There were various appellate division approaches to addressing ORAMA issues at that time, and through a series of reasoned precedent, this court reached in
But just if I-
Walston, Silva.
Just to cut to the chase, if I can, I think before us is the specific question of what we do with the clerical error, right? And so your position, I think, is if there are missing pages of a transcript, that is no different than a classic ORAMA error where the judge fails in the first instance to convey to counsel the contents of a jury note, give them an opportunity to comment. Is that right?
That's correct, and that's
So
especially...
why should that be the rule as opposed to thinking about this under Paris?
Well, that should especially be the case in this individual case, because this has already gone back down to the trial court, who is the ultimate arbiter of the record. And the trial court...
So you would have us decide for a particular kind of clerical error or particular sort of posture? I'm not sure I understand the cabining principle you're proposing.
Well, I think in this case it has already gone down, and the principle is that the record is the record. It arrives in this court, which has constitutional jurisdiction over questions of law.
I thought, correct me if I misunderstood this record, with respect to the 440, the judge thinks that, no, there are no transcripts, but you didn't do enough to try and reconstruct, or to persuade the judge, to order a reconstruction hearing, and that was the opportunity provided that you did not follow up on.
There was a motion made to the trial judge. Yes, that was the opportunity, because there was a motion in the trial court before the very judge who oversaw the trial.
So we do not really know whether or not it would be possible to find out what happened in Note 2.
Based on what, like the representations that were made to us, we don't know more than what is in the record, and the record shows there's no proceeding in the record when meaningful notice was given.
Counsel, that seems to be a very different posture or position you're taking here than you did in the trial court. Because in the trial court, you attached these letters that were talked about, one of which from the senior court reporter says, as a result of the loss of the stenographic notes containing the required proceedings, we are unable to provide the required transcript. And in your brief to this court, you say, to reopen the record for reconstruction, some untranscribed proceeding must have occurred in order to have something to reconstruct. There is no record evidence of an untranscribed proceeding carrying the meaningful notice. How do you square those two things?
To address these questions in turn, the posture is different because when we were in the trial court could have reopened the record and made a record of compliance. The second point is the Goodman affidavit, which is the one you're referring to. Goodman was not the reporter in court on May 25th, 2011.
But the
She has
clear
no
import of that letter is there is notes, there's a transcript, they can't be found, we can't give you the transcript. The clear meaning of your brief to me is there is no untranscribed proceeding.
The most that affidavit can be read for is that the court reporter conducted a reasonable review of their records and could not find a transcript. Goodman had no personal knowledge of what happened on May 25th, 2011. It's not an affidavit from Terry Klein, for example, which maybe could establish whether or not there was a proceeding held. Goodman had no firsthand knowledge. And
Trial counsel didn't look at their file?
There were no jury notes in the file that we received from trial counsel.
Did trial counsel, did you ask trial counsel?
Yes, the final paragraph of trial counsel's affidavit that was submitted with the 440 motion says that he has no recollection of how any of the jury
True, but I
notes were
thought he also said he didn't look at the file.
Right.
There were no notes in the file that we received from trial counsel. And I want to, yeah.
Right, but there's a difference between there's no notes you received from trial counsel and whether he presented an affidavit saying he didn't actually look at the file?
Well, he looked at some portions of the file that were provided to him.
But that's not what he
Yeah.
says. And the fact that there are no notes in his file, the jury notes, I think that's what you meant, right?
Yes,
The
sorry.
jury notes in his file, doesn't mean that if he had looked at the file, it would not refresh his recollection as to what happened. Those are very different things.
I think that's the sort of kind of speculation that, this court's clear around. We could speculate about what trial counsel
Well, I
could
guess that
remember.
also goes
but-
to what, right, the shortcomings in the request and why the judge is giving you another opportunity
Well, the judge,
to try and support the request for the reconstruction here.
well, I want to emphasize here that the respondent consented to reconstruction, and the
Yes.
application of Paris in this context was done sua sponte by the court It was no longer Justice Carter. It was a sua sponte superimposition of Paris, which this court has never applied in the Arana context, and was done without the benefit of briefing or oral argument.
Sorry, your light is on. Could you just perhaps quickly address on the Urana issue, on that testimony? Your friend on the other side, their argument that that testimony wasn't crucial to the people's case.
Oh, well, Urena's testimony was certainly crucial to the people's case. The other two witnesses were 14 and 15 at the time of the incident. They were children. They were strangers to Mr. Salas. The entire theory of misidentification, as I was saying before, came down to no witnesses had prior familiarity with Mr. Salas. All of the witnesses had an interest in the proceeding because they were friends with the deceased, and there was no contemporaneous identifications. The very first witness that the prosecution called rebutted all of those major tenets of the misidentification theory. It was crucial, and I want to emphasize as well that each of the errors that trial counsel made had different effects, but they were all in relation to Mr. Urena, who was the most critical witness, and reflect trial counsel's lack of preparation overall to deal with that most critical
Counsel, I'm
witness.
sorry, one more point. The point on the letters that they could be read different ways, they don't show, defense counsel in the 440 interpreted them to say, this is your motion, the record in this case is incomplete. A key portion of the transcript reflecting the court's and the counsel's handling of jury note 2 is missing. That seems pretty clear. A key portion of the transcript is missing, and you attach the notes from the stenographers saying we can't find the notes, we can't find the transcript. But it sounds like now you're saying the position was no transcript. There's no evidence that there was any transcript of a transcribed proceeding doesn't exist.
I would
It
agree.
seems to be a very different position you take.
Well, and to be clear, we didn't cite Paris either in our briefs. We were citing
I'm talking
Orama.
about Paris. I'm talking about your representations. And one of them was a key portion of the transcript is missing. That shows the court's handling.
In that instance, it is missing because it didn't exist, or it's missing because of error. And to the fact that, there's some sort of factual finding by the trial court, there is no evidence in the record that a proceeding
So
was
what is
held.
your position today? Because you said when you first got up, we don't know there were missing transcripts. So is that your position today?
Yes, the record does not show evidence that a proceeding was
Notwithstanding
held.
everything that came before that Judge Garcia is referencing.
I think that
Your
the
position
record,
is you don't know that there are missing transcripts.
well, I think that our position today is nothing in the record refers to a proceeding that transcripts for which could be missing, but it is
Wait, so
different today.
your position is maybe there was no proceeding, or maybe there is no transcript? Which of those two?
So Orama focuses on whether meaningful notice was given,
Yes,
which has to
and
be
that's
done
what I
in a
mean by a
proceeding,
proceeding,
right?
to be clear.
And the record is dispositive of that.
Yes.
And there's nothing
But
in the
are you
record-
now taking the position that perhaps there was, that you think no notice was given at all, and that it's a classic Orama error? Or are you taking the position that you don't know if a transcript was made, or that the pages of the transcript appear to be missing, so what do we do about that? Those are
We're-
three different options.
We're taking the position today that it's a classic Orama error in the form of Silva and Hansen. And I'd emphasize that it is positioned differently today because it has already returned to the trial court once, which declined to expand the record in there.
And just to clarify, you're taking that position today because, am I correct, that the record as it exists indicates that there were no proceedings regarding this missing jury note?
That's
Is that
correct. The record as it emerged from the trial court after we raised this in the first instance when we had an opportunity on the 440 motion. Yes. The record today, as it exists, having once already returned to the trial court, having already put every party who may have knowledge about what was done on notice, the record today remains, there's no evidence in the record that meaningful notice was given, and we have no reason to believe that all of these parties that we put on notice were hiding the ball from us when we moved in the trial court.
Or a meaningful response for that matter, right?
Or a meaningful response, but that is, again, the same as in Silva and Hansen, those cases too. It was complete silence on those substantive notes, as it is here.
Thank you.
Thank you.